So what do you and a company actually have in common? I know, it sounds like a trick question, right? But the answer is pretty wild. In the eyes of the law, you're both considered a person. But hang on, how can something that doesn't eat, sleep, or breathe be a person? Well, that's exactly what we're going to dive into.
If you're gearing up for your CA exams, you are in exactly the right place. We're about to lay out an exam-focused blueprint for Chapter 6 of the Companies Act 2013. We're going to break down all the core concepts you absolutely have to nail for your business laws paper.
So here's our game plan for today. We'll kick things off with the absolute fundamentals of what a company even is. Then, we'll get into this super interesting idea of piercing the corporate veil. After that, we'll nail down the key differences between company types, get to grips with their two main rulebooks, and finally, we'll lock in some legal doctrines you just have to know. Think of this as your roadmap to crushing this chapter.
All right, first things first. Let's tackle the most fundamental question of all. What exactly is a company when we're talking about the law?
Okay, this definition right here, this is pure gold for your exams. Let's break it down. A company isn't born, right? It's an artificial person that's created through a legal process. It has its own identity, what we call a separate entity, totally distinct from its owners. And it has perpetual succession, which means, it can basically live on forever.
So these four features, you've got to know them. Because a company is a separate legal entity, it can own a building in its own name, not its members. Perpetual succession is wild. It means even if all the members were on a plane that crashed, the company itself would still exist. And then there's the big one, limited liability. This is what protects a shareholder's personal assets. And finally, as an artificial person, the company itself can sign contracts and even sue someone, all under its own name.
So, this separate identity we've been talking about, it creates this kind of shield, or what the law calls a veil, between the company and its owners. But what happens when people try to use that veil to do something shady? Well, let's talk about when the law decides to peek behind the mask. The corporate veil is simply that legal wall that separates the company's actions from the shareholders' personal lives. It's the whole basis for limited liability. If the company racks up a ton of debt, creditors can only go after the company's assets, not the personal homes or cars of the owners. You can see why this protection makes starting a business so appealing.
Now, the case that really cemented this whole idea into law was Salomon versus Salomon and Company Limited. You need to know this one. Here, a guy named Salomon set up a company where he was basically the only shareholder. When the business went under, creditors tried to argue the company was a sham, just Mr. Salomon in disguise, but the court said nope. They firmly established that a company is its own legal person, period. It doesn't matter who owns the shares.
And Lord MacNaughton put it perfectly when he said the company is a different person altogether. This is so important. It means the company isn't just an alias or an agent for its owners. It is a truly separate thing. This single idea is pretty much the bedrock of all modern company law.
But, and this is a huge but for your exams, that veil is not invincible. The courts can lift or pierce it in certain situations. For example, to check if a company is secretly being controlled by an enemy country in wartime. Or, like in the famous Din Shah Manikji Petit case, when someone creates a bunch of companies just to dodge taxes. They'll also lift it to stop a company from setting up a subsidiary just to pay its workers a smaller bonus. Basically, if the corporate structure is being used to commit fraud or dodge a legal duty, the court will look right through it and hold the actual people behind the curtain responsible.
Okay, moving on. Let's get practical and look at how companies are classified. For your exams, the absolute biggest distinction you've got to understand is between private and public companies.
The differences here are critical, so let's break them down. A private company, you can start one with just 2 members, but a public one needs at least 7. Then there's the maximum. A private company is capped at 200 members, while a public company has no limit at all. But honestly, the biggest difference is about the shares. In a private company, you can't just sell your shares to anyone, and you definitely can't ask the general public for money. Public companies are the total opposite. Shares are traded freely, and they can raise money from anyone.
Seriously, burn this number into your brain. 200. It's such a classic exam question. A private company can't have more than 200 members. But, and here's the exam trick, you have to remember the exception. Current employees who are also members and ex-employees who were members while they worked there don't count towards that 200 limit. It's a tiny detail, but those are the details that get you the marks.
All right, every single company runs on 2 foundational documents. A great way to think about them is as the company's constitution and its internal instruction manual. Let's clear up the difference between the memorandum and the Articles of Association.
So you've got the Memorandum of Association, or MOA. This is the company's charter. It's an external document. It basically tells the whole world what the company was created to do, its goals, its powers. Then you have the Articles of Association, or AOA. These are the company's internal bylaws. This document is all about managing things on the inside, the duties of directors, the rights of members, that kind of stuff. So, to put it simply, the MOA is the what, and the AOA is the how.
Okay, let's tackle our final section. 2 legal doctrines that are just non-negotiable. You have to know these. They govern whether a company's actions are even valid, and they offer protection to people dealing with the company.
First up is the doctrine of ultra vires. Now, ultra vires is just Latin for beyond the powers. What it means is if a company does something that isn't authorized by the Objects Clause in its MOA, that action is ultra vires. For instance, in the famous Ashbury case, a company formed to make railway carriages tried to finance a railway line. That contract was deemed completely void. And here's the kicker. An act that is void cannot be fixed or ratified, not even if every single shareholder in the company agrees to it. It's just null.
On the flip side, we have the doctrine of indoor management, which you'll also hear called the Turquoise Rule. This one is all about protecting outsiders. It says that if you're dealing with a company in good faith, you have the right to assume that all their internal paperwork and procedures have been handled correctly. You're expected to check their public documents, like the MOA, but you don't have to snoop around and investigate their indoor affairs to make sure every little internal rule was followed.
But just like the corporate veil, this rule isn't a free pass. It has limits. And yep, this is another huge exam topic. The Turquoise Rule won't help you if you actually knew there was an internal problem. It also doesn't apply if the situation was just plain fishy and should have made you ask more questions, like an accountant trying to sell off company property. And finally, and this is a big one, this rule can't make a forged document valid. A forgery is a total nullity, and no doctrine can save it. So let's do a quick-fire recap of what you absolutely must take away for your exam. 1. A company is a separate legal person with limited liability. 2. The corporate veil isn't absolute. It can be lifted for things like fraud. 3. Know the numbers and rules for private versus public companies cold. 4. MOA is external, AOA is internal. And 5. The Turquoise Rule is there to protect innocent outsiders, but remember its key exceptions.
And that's our blueprint for this chapter. I'll just leave you with one final thought to chew on. Is the corporate veil an essential protection that allows business to thrive, or is it a legal loophole just waiting for someone to exploit it? It's something worth thinking about as you study. All the best!